Hello everyone, I'm Alice Bernardo and today I would like to introduce my dissertation on the practice of child marriage, especially with concern to India. My thesis is titled The Evolution of the Law on Child Marriage in India. Nonetheless, today we are not going to discuss such topic in depth, but rather two extremely important young women called Rukmabai Raut and Fulmoni Dosi, which during the 1800s were the pivoting element which caused the implementation and the development of laws which at least try to limit such practice. First of all, I would like to introduce what child marriage is. Child marriage refers to any formal marriage or informal union between a child under the age of 18 and an adult or another child. In view of the fact that by definition a minor is a person under the age of full legal responsibility or they are not physically, mentally, psychologically or emotionally ready to reach their fullest potential, such practice cannot be considered consensual. Globally, more than 640 million women are married as young girls, with at least 12 million girls getting married before turning 18 each year, which means that 21% of young women are married before their 18th birthday. It is worth to note that this represents a decrease of 25% in the last 10 years, which is driven predominantly by progress in India. First of all, I would like to introduce Rukmabai Raut and her husband Dadaji Bikaji. Rukmabai was born into a Marathi family and was forced into marriage at the age of 18 with 19-year-old Dadaji Bikaji. The marriage was never consummated thanks to the support of her stepfather, and in the future she devoted herself to studying and social activism, allowing her to come in contact with influential reformers. On the other hand, Bikaji distanced himself from the family and fell into debt. In 1985, Rukmabai case became an iconic legal battle when her husband filed a suit for the restitution of conjugal rights, claiming that in the 11 years of marriage, his wife had never lived under his roof. Rukmabai firmly refused to live with him, denouncing child marriage and the subjugation of women in Indian society in a letter which was later published in the same year. She proposed in this letter some radical reforms, which included the annulment of marriage not sanctioned by the government, a minimum marriageable age of 15 years for girls, and legal penalties for parents who sold their daughters into marriage. Justice Pini ruled in Rukmabai's favor, recognizing her rights to autonomy and stating that young women could not be forced to consummate a marriage arranged for her in helpless infancy. The verdict sparked mixed reactions. In fact, some saw it as a landmark statement for women's rights. Others, on the other hand, view it as an attack on Hindu marriage tradition. However, in 1986, the Bombay Appeal Court overturned the judge ruling, arguing that Hindu marriage did not require the consent of the bride. Later, in 1887, the High Court ruled that Rukmabai must either go to her husband or face 6 months of prison. However, she refused, declaring that she would rather go to jail than submit. Finally, in 1888, the case was settled through a financial agreement in which Bikaji accepted compensation, granting Rukmabai her freedom, and she later traveled to England to study medicine and becoming one of India's first female doctors, dedicating her life to healthcare and women's rights. We can state that her courage and determination played a crucial role in shaping reforms against child marriage in India. Another extremely relevant young girl is who shaped the introduction of the Age of Consent Act of 1891 is Fulmoni Dosi. Pulmoney was an 11-year-old Bengal girl who died in 1889 after sustaining injuries during forced sex, or we can say rather rape, with her 29-year-old husband. This case highlighted the issue of child marriage, as Hindu law permitted cohabitation with child brides, and additionally colonial law stated that only sexual relations with wives under the age of 10 could be considered actually rape. The only outcome of the debate was the raising of the age of consent from 10 to 12 years old, which is a change that actually was also rejected by the scientific community, which stated that there was no real difference between a 10-year-old girl and a 12-year-old one. Over the decades, numerous feminist organizations and the National Commission for Women have criticized the judicial approach towards child marriage. In fact, in 2006, after a 2-year legislative process, the Prohibition of Child Marriage Act was introduced, which primarily defined a child as any individual under the age of 21 for men and 18 for women. The act differed substantially from the original bill regarding the nullity ab initio of marriages involving minors, and neither was a marriage registry introduced to allow an effective prevention of child marriages. It is important to acknowledge that early marriage became a common practice during the so-called Smriti period. Subsequently, in the medieval era with the Mughal colonization, the phenomenon of child marriage spread mainly due to concerns over security in a time marked by frequent invasion and conflicts. Under British rule, colonial administrations were generally reluctant to intervene directly and deform this area. Instead, the main impetus to change came from the Hindu elite, which advocated for reforms and transformations. Additionally, we can say the feminist groups also played a crucial role in bringing greater visibility to the issue, pressuring and compelling the Crown to take actions. At the international level, we can observe an evolution and strengthening of the rights of young women and women over the year. In response to the recognition of the unique challenges and discriminations faced by women and young girls, numerous treaties and conventions have been drafted. However, in relation to child marriage, particular attention should be given to two different conventions. The first one is the Convention of Consent on Marriage, Minimum Age for Marriage, and Marriage Registration of 1962, which is the most comprehensive and exhaustive document on marriage-related matters. And this convention reaffirms the consensual nature of marriage and requires signatory states to adopt a legislative measure establishing a specific minimum age for marriage. Consequently, non-marriage should be considered legal if contracted by a person below the stipulated age and without the free consent of both parties. The second convention we find is the Convention on the Elimination of All Forms of Discrimination Against Women of 1981, which establishes that the betrothal and marriage of a minor should have no legal effect, mandating the adoption of a minimum age for marriage and making compulsory the registration of marriages in an official registry. We can observe that Indian law is not entirely aligned with international convention. In fact, we can state that it is difficult to determine whether the prevalence of early marriages can be attributed solely to colonial Britain or exclusively to Indian traditions. Nevertheless, I do believe that both have played a significant role in the failure to protect young girls and women in general. Fortunately, we can state that feminist movements have had a significant influence, although the road ahead is still pretty long, as child marriage has not yet been entirely prohibited. In conclusion, I consider it important that all women express their gratitude to Rukmabai and Pulmoni, as the impact of their stories is undeniable. It is thanks to their sacrifices in terms of rights, freedom, and in Pulmoni's cases, her very life, that we can now read legal texts which are aimed at a better protection of women. However, it is inevitable to acknowledge that the problem has not been completely eradicated. I want to remember that today still 1 out of 5 women is married before the age of 18, so this should really sink in still the prevalence of child marriage. Thank you for your attention.